I'm Jennifer Dye. I'm a librarian at the Detroit Public Library, and I've been working for the last 2 years with members of the Detroit League of Women Voters chapter on these programs that we present mostly monthly online, which we found has worked better, and we can reach a broader audience that way. You were brought into this program muted. You can put your questions into the chat. Ruth Coolwine will capture these questions and ask them at the end of the presentation. We might be able to allow people to unmute at the end of to ask questions directly, if time allows. And this presentation is being recorded, and it will be made available on DPL's and the Detroit League's websites. Cheryl Buckoff of the Detroit League will speak briefly about the League of Women Voters.
Thanks, Jennifer. Sorry, I've somehow gotten a frog in my throat. The League is a nonprofit, nonpartisan political organization with national, state, and local components. For a century, we have worked to empower voters by informing citizens about local candidates, public policy, and advocacy programs. We encourage active participation in the political process. The League does not endorse or support candidates or political parties. We conduct candidate forums, register voters, hold informational meetings, and advocate for voters' rights. We work to engage Detroit, Hamtramck, and Highland Park citizens in local governance, decision-making, and issues of interest. Our membership is open to everyone. We seek diversity, equity, and inclusion in all our endeavors. So join, because you can be a force for change by joining our league for your community, yourself, and your country. I know there are other people here who are from other leagues, so we're happy to see that too. Remember, democracy is not a spectator sport. I will be putting information about membership in our league if you have any questions in the chat at some point. So thank you. We're very happy to be able to co-host these forums.
Thank you, Cheryl. Our speaker tonight is Tyler Augst. I think I got that right. He is with MSU Extension. He is the Government and Community Vitality Coordinator. He will present tonight on the Michigan's Open Meetings Act and talk about the problems in it and the implementation of it. And we hope that we will be able to answer your questions. Please do put questions in the chat. They will be passed on, and we will ask at the end of the program. Thank you. Tyler?
Yeah, thank you, Jennifer. Thank you, Cheryl. Thanks, everybody, for joining tonight as we get started here with our program for the evening. Like was said at the top, my name is Tyler Augst. I'm an educator with Michigan State University Extension, and thankful for both the League of Women Voters in Detroit and the public library there for inviting me tonight to talk about the Open Meetings Act. So tonight we're going to go over kind of the basics of the Open Meetings Act. After this presentation, you'll be getting some additional resources, including the slides and a really valuable document from our Office of the Attorney General here in Michigan that goes through a lot more details about the Open Meetings Act, or, we're going to be getting familiar with it tonight. So we'll just call it the OMA from here on out, probably. But thank you, everybody, for joining tonight. Like they were saying, if you do have those questions, please get them into the chat box. So we've got some good back and forth that can happen here at the end. And yeah, without any further ado, we'll kick it off with how all MSU Extension programs begin, which is with this slide you're seeing now. We call it our End Justice for All slide. This is just a reminder that Michigan State University Extension programs are open to all. We are an equal opportunity employer, and our programs, anybody can attend. We want our programs to be a place where participants can feel welcomed and like they can learn and fully participate. The values of diversity, equity, inclusion are ones that we hold dear at MSU Extension. And if ever at any point we're not living up to those values, please let myself know, let our partners know, let the folks on campus know. Just tell somebody so that we can improve and more fully live into those values. Like I said, my name's Tyler Augst. I'm with Michigan State Extension and Michigan Sea Grant, and I'm a government and community vitality educator. And I tell folks that's a lot of fancy words, but all it really means is I'm here in Southwest Michigan, Van Buren County, to provide education, outreach, training, support to local government, elected and appointed officials, residents, leaders, anybody who's asking. So I work out of our Van Buren offices in Paw Paw, covering generally Southwest Michigan, but also do programs around the state through the magic of Zoom technology. And my main areas that I focus on are planning and zoning, lots of education around that, good governance like the OMA tonight. And then with that Michigan Sea Grant piece, I also get to do a lot of work with our coastal communities since we have so much shoreline here in the state, working on issues of coastal development, coastal planning and zoning, tourism, and related sort of government and community topics. Of course, want to call out some of my awesome colleagues who have helped prepare the materials I'll be using tonight. These are some other members of our government and community vitality team from up in northern Michigan, or as like John likes to call it, Knuckles North on your hand map of Michigan. But just want to acknowledge our co-author. And just a quick introduction to MSU Extension for anyone who is new to our programs. MSU's Extension's mission is helping people to improve their lives through an educational process that applies knowledge to critical issues, needs, and opportunities. Extension has been active here in Michigan for over 100 years, providing program in all 83 counties in Michigan in the areas of agriculture, 4-H and youth development, health and nutrition, and community and natural resources development, like the issues I work on. So if you ever have needs for any of these areas, please reach out to your local extension office. Even if you have that question, you're not sure where to go, give them a call. We're really good about figuring out who has the answer and are more than happy to help. So in this program, we're going to cover a few different things, starting off with just some basics about the Open Meetings Act. And then from there, we're going to kind of break things up into what needs to happen before the meeting under the Act, during the meeting, and after the meeting. And then towards the end of the program, we'll get into some of the consequences for violations of the Open Meetings Act, and then also talk through public participation at these open meetings. That's one of the areas we get a lot of questions about at MSU Extension. So we've got a few slides to sort of go into some more details there. Again, as you have questions, please get them into that chat box so that we can cover them towards the end of the program. But I am going to jump right in to some OMA basics. So on this slide, given that it's a League of Women Voters type crowd, you might already know this, but to make sure we're all on the same page, you see two different types of citations on the slide that's showing right now. And this is how we refer to laws in Michigan. The first one is PA is short for Public Act. So the OMA was Public Act 267 of 1976. The other way we cite laws is through this MCL, stands for Michigan Compiled Laws. And so you can see here the MCL citation. If you wanted to go look up a copy of the OMA, you can go to the legislature's website, type in that 15.261, and it'll take you right there. I've been reading through my copy here over the last couple of days to prepare. And honestly, it's one of our shorter statutes. It's only about 9 pages. If you're looking to get involved with reading statutes, it's a good one to start with. So the Open Meetings Act has general rules and definitions, but like all of our laws, those rules, definitions end up getting interpreted by our courts through case law and also through what are called attorney general opinions. And you'll see we'll reference some of these court cases as well as Office of the Attorney General opinions throughout to help us understand some of the nuances of this law that might not be expressly written out. And a thing to remember in these interpretations, they have always interpreted the OMA in favor of openness. So thinking about that as sort of our guiding belief here, you're not going to get, our public bodies are not going to get into more trouble being more open. The courts always lean towards that side of transparency. So the spirit of the OMA actually dates back to some of our early Michigan constitutions, with language like the 1850 Constitution, which includes that, quote, the doors of each house of the state legislature shall be open. That idea of openness in government. This act sets the minimum standards for openness in meetings. It took effect January 1st of 1977, and this is the Watergate era, if we think back to that time in our history. And it's, to some extent, this was a response to that lack of trust in government that was bubbling up at that time. So nothing in the OMA prohibits a public body from adopting an ordinance, resolution, rule, charter, provision that requires a greater degree of openness. But know that that OMA sets the standard. We can always go above that standard set. Also, again, just a reminder that the judges are ruling on the side of being open and transparent when we look through the case law. And if you were to type in the MCL citation and pull up your own copy of the OMA, it's broken into sections. The first two sections, pretty basic stuff for a state statute like this. You get the title, Open Meetings Act. Section 1 also outlines that, this law supersedes local provisions. But again, those local units can adopt a greater degree of openness. Moving into section 2, that's where we get all the definitions for these important words that we're going to be talking about throughout the rest of our time together. Some of those important terms are public body, meeting, decision, and we're going to go through each of them in turn. So on this slide, in the next couple, the colored words in that sort of orangey red, bolded, are some of the key terms that we're going to define and are defined in the statute. But the OMA, as a general rule, any person has a right to attend a meeting of any public body at any time unless a specific statutory exception applies. Those exceptions might be things like closed meetings, which we'll talk about in a little bit. But it's really important to remember, these public bodies, they're doing the people's business. They have that fiduciary role, being for the benefit of others, and conducting that meeting out in the public is one of those ways to ensure we're meeting those responsibilities. So that last slide talked about a public body. That's one of the definitions we see from the OMA. And a public body is a group that is empowered by state constitution, statute, charter, ordinance, resolution, or rule to exercise governmental or proprietary authority. So these are your things like your boards, your councils, your township board, city council, village council, county commissions, authorities, committee of something, subcommittee of something. Any of those bodies that are doing the work of government. So when those public bodies come together, they're going to be bound by the Open Meetings Act. There are some other exceptions carved out in the OMA. They get into some of the really niche boards, but just think about, board councils, those elected positions appointed, public bodies. And then a meeting, another key definition. A meeting is that convening of a public body with a quorum present for the purpose of deliberating towards or rendering a decision on public policy. Now, the key here is that deliberating towards or rendering a decision. So there are times when you may have a quorum of a public body together, but it's not a violation of the Open Meetings Act. A good example that we get a lot here at MSU Extension, conferences, trainings. When we hold a training for local government officials, they'll often send a couple folks. But these conferences aren't deliberating toward or rendering that decision about public policy. They're for education. So when all of my school board goes to the Michigan Association of School Board training, we're there to learn. We're not going to talk about our policies or talk about making a decision based on what we're learning. We're learning right then. When we talk about applying it to the public body's decision, we'll do that back home at an open meeting. So just know that there are certain exceptions and some other ones that come out of the OMA. Again, you get some exceptions for some real niche things like public bodies when deliberating the merit of a case, and like workers' compensation and unemployment boards can be accepted. But these are some of those specific carve-outs you see in the language of the statute. And then decision, another key term to understand. And the OMA is defining a decision as a determination, action, vote, or disposition on which a vote by members of a public body is required and by which a public body effectuates or formulates public policy. Really, again, this is a lot of legalese. So trying to break it into what does that mean? It's when you're narrowing down the choices, that's a decision. It could be a motion or a proposal or a recommendation, but anytime you're narrowing that number of choices, it's making a decision. And if a public body is making a decision, it needs to be in a public meeting. So thinking about even recommendations, if it's eliminating potential options, is making that decision towards public policy. Again, the OMA has lots of very specific exceptions that get carved out. Another one here is if there's a committee adopting a non-policy resolution of tribute or memorial, those can be exempt from the OMA because not quite that public policy, and the OMA specifically exempts it out to allow those things to kind of move through. Quorum, this is a fun term that's actually not defined in the OMA. We've been talking about it right when that quorum gets together, but the OMA doesn't expressly define it. Instead, we may need to look to another statute or the bylaws or rules of procedure for a particular public body or board. And this slide has a strike through there at the bottom for there were some changes during the pandemic when we had various COVID-19 amendments to the OMA that allowed for virtual presence to be counted towards a quorum. But we've changed the OMA since then, and we'll get into what the current stance is on virtual presence. But just know that quorum is something you're going to have to look somewhere else to define, whether that's another enabling statute like the Zoning Enabling Act, Planning Enabling Act, or Michigan Township Act, but looking for that somewhere else. And another note on this slide, those bylaws or rules of procedure, the OMA doesn't require them, but we highly recommend them, and other statutes may require them for the particular public body that's been authorized under that statute. So that takes us through those sort of first two sections of the OMA, that title and purpose, some of those key definitions. And now we're going to start moving into, we'll call it meat and potatoes of the act, getting into some of what it actually does and how it applies to public bodies. So in section 3, that's where we really start to focus on the meetings, deliberations, decisions, all those things we defined. What are the laws being set up around those through the OMA? It's critical to understand those definitions as we start to get into the other aspects of the Open Meetings Act. But section 3 starts off talking about how all meetings of a public body shall be open to the public. And if you played around with state statutes at all, you know, shall means you're going to do it. You don't have a choice. So all meetings of a public body will be open to the public. All decisions of a public body again, shall be made at a meeting open to the public, and all deliberations of a public body constituting a quorum of its members shall take place at a meeting open to the public. So if you're deciding or deliberating, then you need to be in a open to the public meeting. So I mentioned that during the pandemic, we had some amendments that allowed for some different things as we were taking public health measures. And one of those things was virtual participation in meetings. Those public bodies we've been talking about were allowed to hold wholly or partially electronic meetings, either by telephone or video conferencing, all the way to the end of December 2021. And it could have been because of military duty that somebody was absent, a medical condition, or a statewide or local state of emergency, like the one we were experiencing with the pandemic. However, effective January 1st of 2022, the only legal basis for a member of a public body, so this is somebody who's actually part of the body, to participate in a meeting via telephonic or video conferencing as a member of the public body, is if you're absent due to military duty. We do still have that carve out in the OMA for virtual participation for those who are doing their service overseas or absent for some other reason because of that duty. But everybody else in that public body is expected to show up in person to participate as a member. So this amendment to the OMA eliminates that previously permissive practice of a public body allowing its members to participate and vote remotely. So we've seen some changes over those last couple of years, and for a while it was a little tricky keeping up on all of them. So I wanted to include this here as where we stand now with virtual participation of public body members. Another thing that's come out of that post-amended OMA time is this Michigan Attorney General opinion from February of 2022. So this would have been shortly after we had gone back to requiring public body members to be in person. And in this Attorney General opinion, it says that the American with Disability Act, ADA, and our Michigan Rehabilitation Act require that state and local boards and commissions to provide reasonable accommodations, which could include an option to participate virtually to those qualified individuals with a disability who request that accommodation. So you're going to still see virtual meetings happening. A lot of times they're streamed out or broadcast so that folks can be aware of what the public body is doing and not have to physically go to the building. But just notice that even when you're watching those virtual meetings, as a member of the public watching, the members of the public body, the ones actually making the decision and discussing, are all going to be there in person unless they have that military duty exemption. So this is our quick little run through some of the basics of the Open Meetings Act, thinking about, is a decision being made? Is it a public body? Are deliberations happening? If so, you should be at an open meeting while this is going on. So that's some of our basics. And like I said, now we're going to move into thinking temporally about the OMA. What needs to happen before a meeting? What needs to happen during the meeting? And then afterwards. So there are many critical elements of the OMA that actually occur before the meeting. A basic element of due process is to allow people the ability to attend a meeting to hear those deliberations and decisions. The Open Meetings Act has a number of critical timing elements to give individuals reasonable and timely notice that a meeting is taking place. So if you're going to be doing the public's business, they should know when and where you're doing it, right? So this is where the idea of a meeting notice comes in. And these meeting notices need to include some specific things that are called out in the OMA, the name of the public body. So here on our fun example, we have the Anytown Municipal Planning Commission. Remember, I said I did a lot of planning and zoning work. Also needs to include the phone number, physical address, and the date and times of its regular meetings. So you can see on our example here, You can see on Wednesday, March 23rd, 20XX at 7 at our municipal hall, there's going to be meeting of our planning commission. So some of these key content things are important to make sure they get into these meeting notices and help the public understand when and where and how to participate in these meetings. These notices must always be posted at the principal office of the public body, unless there is no principal office, and then they shall be posted in the office of the county clerk. So again, there are going to be some set places where you know to go and check for these notices so you can stay up to date on what's happening with your public bodies. Now, fun provision of the OMA is that you can actually sign up to get these notices. Maybe driving to the local township hall to check their bulletin board, not the most convenient. So there's actually a section of the OMA that says that a public body must send copies of those public notices through the mail to a requesting party. All that party has to do is request the notices and then pay a yearly fee, not more than the reasonable cost of printing and postage for sending out those notices. So you can go to the clerk of your local unit of government or whoever's in charge of these notices for a public body and ask for those copies to be sent by mail to you. And an important thing to note about these notices is that while the OMA requires a public body to give that public notice when it meets, there is no requirement that the public notice include an agenda or a specific statement as to the purpose of the meeting. And there's no agenda format required by the OMA. So this may vary. Some other public bodies like a planning commission have additional requirements from other statutes that say you need to say what this meeting is about. But from the OMA perspective, there's nothing that says you need to have the agenda noticed or what the topic is going to be. There is one thing on that agenda that the OMA requires, though, and that is a public comment period during a public meeting. Every public comment or every public meeting must have at least one public comment period as required by the OMA. So moving on to that timing of that notice that contains all that information. So the notice lets you know where and when you need to go, but it's also important to know when the public bodies need to get these notices out. So for regular meetings, and this is a fitting topic for January because lots of public bodies are probably working on this right now, but they need to post their annual calendar of regular meetings within 10 days after the first meeting at place of business. So this is the time when everybody's setting that calendar of meetings for the year for public bodies and then posting it at their principal office or with the county clerk if none exists. And then we all know life happens, right? Something comes up, there's a deadline, you need to get another meeting in. So you can change that schedule of regular meetings. The OMA just requires it needs to be within 3 days of the meeting. 3 days in advance. So you have to have that 3-day notice for those changes. And again, posting it for the public to see. Here, just another note on this slide. I say January, a lot of them are happening. But again, it can be the calendar or fiscal year. So maybe yours isn't doing it right now, but that's because they're on the fiscal year. So just know that you should be able to find a calendar of regular meetings for any public body you may be interested in. Apologies while I wet my whistle there, but another important piece on timing is, again, that theme of life happens. Sometimes you need to reschedule a meeting or call a special meeting. And these meetings also have timing requirements. You need to, if a meeting needs to be rescheduled or a special meeting called, you need to post that notice 18 hours before meeting at the place of business in a prominent and conspicuous place. And we have a note, this also applies if a meeting was happening and the public body decides to recess for more than 36 hours. They'll need to post this notice again with the 18-hour requirement.
Yeah.
Now, one of the things that we often get questions about from public bodies is where can this be posted? And you can see we got another citation here. This is getting back to that Office of Attorney General. So this is another one of their opinions that interprets this law, but that 18-hour notice needs to be accessible. You need to be able to see it as a member of the public. So if the posting board for the public body is inside the breezeway on a bulletin board, can you see that from the outside after they close their doors at 5 p.m.? If not, those hours aren't going to count. So what I've actually seen is public bodies or local units of government will put these types of notices right on the exterior window, so it's visible any time of day. I was even in a township last year where they had a really great little handcrafted thing that was a couple wooden stilts up to a document holder that would get the document high enough to be seen through the window. So they could just slide a notice in there. And everybody in the township knew, yep, you look in that window and that's where notices go. So again, the OMA lays out all of these timings. So if you're ever wondering, you can go back to the Act to check, or again, some of the resources I'm going to be sending go into the details about this too. So here on the slide, we have an image of the County of Manastee's website. And we're throwing it up there as an example of an active website. This is an important term because these notices for those rescheduled or special meetings, if you have that dynamic or active website, then the notice needs to be put on the website in a prominent location. Like the active calendar you see here, now a little outdated for September 21 from Manistee. And again, keeping that 18 hours in advance rule that we were just talking about in mind. And so this active website, it's an internet presence that includes monthly or more frequent updates on a portion of the website that is fully accessible to the public, of public meeting agendas or minutes. So you've probably seen a lot of your local public bodies with a website like this. We can get on and download the minutes after they're posted or the agendas. And making sure that the notices get up onto those websites is important for these public bodies as well. Again, if this is a place where people are going for information, we should be putting those notices there. Now, we've talked a lot about lead times, making sure that you have at least that 18-hour or 3 days, or making sure those notices get out in time. But sometimes emergencies happen in government, like a water or a sewer main breaks. And 18 hours could be catastrophic before making a decision about whether or not you're going to replace that sewer line or buy that new pump that you need for your wastewater treatment or whatever the emergency is. So the OMA contains an exception for those emergencies, but it also lays out very careful protocol that must be followed in these unique circumstances. So if there is to be an emergency session, and it has to be in the event of, quote, severe and imminent threat to health, safety, and welfare of the public, then it requires 2/3 vote of the members serving to decide if the delay would be detrimental. And then you have to go through this process. You have to, after 48 hours, the public body needs to send an official correspondence to the county commissioner of the county in which it's principally located, letting that county commission know that they held an emergency public meeting with less than 18 hours public notice. So you're kind of sending it out there, letting the county know, hey, heads up, this happened. And, they'll be able to see why and see that there was a 2/3 vote and make sure, again, just making sure we're keeping open and transparent in the spirit of the OMA. So that's a lot of work, and we haven't even gotten to a public meeting yet. This is all that hard work that our elected, appointed, and local government staff are going through to make sure these notices get out everybody knows that the meetings are happening and can show up and be a part of the process. So notices have gone out from a public body. Everything looks great. We know that a meeting is going to be happening. We want to go. So what can we expect during that meeting? So during a meeting, whether you're attending in person or virtually, know that the public has a right to address the public body. That gets back to that public comment period we were talking about. However, the public body may establish written rules that govern that public comment in advance. The key here is making sure that everyone is given a right to speak. And we have this question at the bottom of the slide to ask, does your board have board rules or bylaws? Because a lot of times this may be where these rules governing public comment live. And looking to those bylaws or rules of procedure can help you understand, as an interested resident, what you can expect when you go and wish to make a public comment at one of these meetings. Now, a public body may establish reasonable rules to minimize the disruption of the meeting, but of course, you can't always prevent it. Some of the things that you can't do, or public bodies can't do, is they can't require registration as a condition of attendance. So to attend a meeting, anybody can do that. That's in the OMA, you can just go. Public bodies can't require you to give your name, sign the sign-in sheet. Now, I've been to plenty of public body meetings where they ask me to. They like to include it in their minutes. I like to let people know where I am. So I'll sign in. I've also been to public bodies where they go around the room, ask everybody to introduce themselves, get that real small town feel of, hey, we're all neighbors here. Again, they can ask, but they can't require for attendance. We're just talking about attendance at a meeting right now. When it gets to that public comment, wishing to speak to the public body, that's when they get into establishing and recording rules governing that public comment period. But again, those rules can't make it so that somebody isn't allowed to speak. Oftentimes we'll see rules like each public commenter has 3 minutes to help facilitate moving along. They still get the chance to speak, but we're going to put some guardrails up so that we can get to the business of the meeting after this. And as we're often seeing these public bodies allowing remote attendance for the public. So you want to make sure that if you're going to a public body and they're doing this remote option, they should have it set up so that everybody can hear. If they're letting folks virtually participate through public comment, got to make sure there's that two-way. So there's lots of things to take into consideration here. And remember, for the members of public bodies, as of January 1st, 2022, only those who are due absent to military duty can attend and participate remotely. So one of the things that often comes up when we give this presentation to elected or appointed officials are texting and emails. We live in a digital age, and it's caused us to have to think a little bit more about how we interact when considering the OMA. So when we talk to public officials, we urge them to have caution with texting and emails before, during, and after a meeting. Emails to members, notes of telephone calls, all of those can be a public record. So think about our public officials need to be thinking about how they're using those. And also thinking about before the meeting, making sure we're not communicating as members body and breaking the OMA by having discussions outside of an open meeting. Because think about it, if you start having an email thread, or your elected officials do, and all of a sudden the whole board is talking about what decisions are going to be made, that's not a meeting open to the public. That's just in their inboxes. So it's violating that spirit of the Open Meetings Act and could run into some risks for that public body. So we encourage elected and appointed officials to really think carefully about hitting that reply all. We also ask folks to really think about using those devices during a meeting. If you have a couple members of a public body who are both out on their phone texting, may be totally unrelated, but as a member of the public, you have to always think about what that looks like. And to a member of the public, it might look like a side conversation that isn't being out in the open. So I know when I'm serving on my board, the phone goes away into the purse. We don't pull that out. I've got notes up on a laptop, but that's it. And I'm engaged in the meeting in front of me. So just some things to be thinking about as you go through your OMA learning journey, thinking about that electronic communication and how it all applies to that too. Now, I've talked a lot about openness, being open, but there are some instances where a public body can go out of the public into what we call closed session. Now, these reasons for going into a closed session are very limited and expressly called out in Section 8 of the OMA. And going into a closed session, it needs to be for one of the reasons listed in the OMA. And all closed sessions need to happen within an open meeting. So there will be a motion and a roll call vote in an open meeting to go into closed session. And if you read the Michigan Attorney General's Guide to the Open Meetings Act, they actually encourage public bodies to, in that motion, expressly call out what the reason is for going into closed session, so that the public knows and it's in the record that we are going into closed session under Section 8B of the OMA. In that closed session, the public body needs to take separate minutes because they need to be sort of curtained away from the public ones. These are closed session and can only get revealed under certain circumstances. But once they go into that closed session and the public is ushered out of the room, the public body can only deliberate. You can only have that discussion. You can't make any decisions in a closed session. The decisions need to be made in the open. Thinking back to our first couple slides, right? Those basics of the OMA, decisions of a public body need to be made in the open. This is speaking to that. So public bodies will often get together, have the closed session, talk through the issue, go over all of the information. Then they'll vote to come out of closed session. And this is a little wonky spot, but yes, they're voting and making a decision, but it's not towards public policy. So this vote to come out of closed session is totally okay. And then they'll bring the public back in, and that's when they actually make the decision, is once we're back in a full public meeting. So I said that there's only a limited number of reasons to go into one of those closed sessions. 12 of them, in fact, in the Open Meetings Act. There are 6 that apply to all public bodies, 6 that apply to specific public bodies like school boards or other ones, and an uncomfortable subject that might be awkward to discuss in public is not a reason to go into closed session. None of those 12 are awkwardness as a reason for closed session. The OMA is very specific. And those closed sessions, again, you're keeping the separate notes, or the public body will keep separate minutes, because what's talked about can be protected from FOIA release, such as a legal opinion. Talking about that in closed session. And then again, it's going to require that roll call vote for the reasons listed here. And again, this is getting really into the technicalities of the OMA and those specifics. I know in my private life and my elected position, whenever I need to do this, I bring a copy of the OMA because I do not remember which one is A and which one is I. But just know, those closed sessions are going to have a very clearly defined purpose when a public body goes into them. So that's during the meeting. Most of that, there will be the deliberations. Your board, the public body or board will, go through their agenda, do their business. And then after the meeting, there are a few things that need to happen as well as required by the OMA. So again, we're not done yet. We've had a great meeting. We got a lot of work done, doing good things for the people. That public body still has some requirements they need to meet. And a lot of these revolve around the meeting minutes. So The meeting minutes must be approved at the board's next meeting. And those, you'll see a public body review the prior month's minutes, make any needed corrections, and then approve them. And before that next meeting, though, the draft minutes must be made available to the public 8 business days after the meeting. So if you missed out on a meeting, you're wondering what happened, after 8 days, you can contact the public body and ask, how do I view the draft minutes? It's been 8 days, they should be available. So oftentimes they're at the location that's posted on the meeting notice. You have to physically go there. They may let you have copies at a reasonable cost. Some public bodies actually post them on the website to save everybody some time and money. It's going to vary for each public body. Again, our OMA is really just setting the minimum standards here. So we see communities and public bodies around the state go to different levels above that sometimes. So those proposed minutes are available within 8 business days of the meeting. And then at the next meeting, the body will approve their minutes, and those minutes will be available for the public 5 business days after the date of approval. So just know that, relatively quickly after these meetings, you can go and get an update of what happened. See, those draft minutes are the final minutes. Now for closed sessions, those minutes, you're very likely not going to be able to see those. They're not available to the public because, again, these are just the deliberations that the state legislature had decided could happen in a closed session. And any decision will be made in a public meeting. So that will be reflected in the public minutes. But those closed session minutes do still get retained in a sealed envelope, ideally, clearly labeled, and then destroyed after 1 year and 1 day, unless there's current litigation. So if there was a need for them to come up, they're there, sealed away, but then there's a retention schedule for those closed meeting session minutes for public bodies. All right, so moving into consequences from the OMA. We've laid out a lot of rules about noticing, about public comments, about due process through having things be discussions out in the open. We've talked about the meeting minutes. What about if a public body gets a piece of this wrong, forgets a step? Maybe there's a new clerk and getting up to speed, missed that 3-day window. What are the consequences for some of these violations of the Open Meetings Act? And so a decision that's made by a public body can actually be invalidated by a court if that public body didn't comply with the requirements of the OMA in making the decision. So if you're violating the notice requirement, a court, or if a public body violates that notice requirement, a court may say those decisions are invalid. And failure to give notice, they'll see if it's had what they call interfered with substantial compliance, or they'll look for if it hindered the public's ability to participate. So if failure to give that notice, this is section 5 of the OMA, then if it's impairing the rights of the public under the OMA, there's a good chance a court may strike down the decisions made at that meeting because due process wasn't given to the public. If you didn't notice it properly, the public doesn't know where to go or how to participate in this process. So if I've actually seen public meetings canceled at the last minute because a sharp-eyed public body member or a staff caught a mistake in the notice and realized, oh, if we go through with this, we're going to have even more problems. So let's pump the brakes, re-notice this properly, and then have our meeting to make sure we're complying with the OMA. So for these violations, to get to the consequences, the Attorney General, the county prosecutor, or any person may file a civil action in circuit court to challenge the validity of decisions or to compel compliance with the OMA. So that challenge, though, needs to be filed within 60 days of the approved minutes. So that's why some of those timelines after the meeting become so important about when minutes get approved and making sure you can see them within 5 days after approval. So you can make sure if they're going to be challenging, you need to get within these time windows. An important note there, though, is if there were contracts or something else, that time limit, our time window actually shortens to 30 days if there was a contract, an acceptance of bids, or issuance of bonds, because those sorts of things move quicker. So you need to get on that challenge quicker if it's going to be contested. And if they're challenged and they win, then get costs and actual attorney fees for going through this process of challenging that validity. And oftentimes you'll see some of these cases end in what's called a writ of mandus, where it's an order from a court to an inferior government official, ordering them to properly fulfill their official duties or correct some abuse of discretion. So what about if a public body realizes that, oh no, we might have not noticed that right, or there was something else that's causing us to be in violation of the Open Meetings Act? So a public body actually has a great opportunity in the OMA to correct a mistake. That public body can reenact the decision, basically doing it over, but correctly, and allows the act to kind of be self-policing in some cases. If a public body is realizing it did it wrong, you can correct it. They can correct without penalty. You get a do-over even if civil action is initiated. And if the board acts quickly, the reenactment might defeat a claim for attorney fees, or since the plaintiff, the one bringing that complaint, would not be successful in obtaining relief from the action because the public body had already reenacted the decision. Now, for a public body, this isn't making any admission, and that reenacted decision just becomes effective on the date of reenactment. And that prompt reenactment can really be a good tool for public bodies' toolbox for if you do notice a mistake, or if a member of the public brings one up, they can quickly correct it and save a lot of legal trouble down the road. So there are some penalties associated with these violations, really for intentional violations. Can be considered a misdemeanor with some fines associated. There's also some personal liability for those members of public bodies if they're doing these intentional violations, up to $500. So know that while yes, the Open Meetings Act is written with that do-over and that idea of self-policing, it also does have some provisions that allow for penalties and fines to be levied. And here we have a court case continuing with our tour of citations down here at the bottom. This is a court case citation that speaks more about these penalties around violations. All right. So that's a lot about the OMA, but I said we're going to save some time at the end here for one of the areas where I and my colleagues get a lot of questions, and that's the public participation part of the Open Meetings Act, the public comment as it's more commonly known. And I'd like to start this section out with a story of back during the pandemic. It was a virtual meeting, and I was sitting in listening to a city council meeting, and they were going through public comments, public participation. And if you remember 2020, 2021, public comments got a little interesting in those virtual settings sometimes. And so at this particular meeting, a commenter came up and they had their 3 minutes to talk. Quick little comment. I think the mayor looks like an egg. And then exited the Zoom. Well within their rights to comment and address the city council with that, the mayor, great sport, took it totally in stride. Well, I like to think I'm a good egg. Thank you, moving on. But that's just my little story to illustrate that these public comments, they can often be contentious. There's a often inherent power dynamic between the people speaking and the people sitting up on maybe that even rise dais, making these very official decisions. So when we teach to elected and appointed officials, we say, it's important to keep that in mind and make sure as you're going through public participation to set some expectations at the beginning. Let folks know what this is going to look like. How do they participate? In the follow-up materials to this program, I'm including a sample brochure. It's probably a couple years old now, but from the Sault Ste. Marie, Michigan Board of Education. They have a great little pamphlet that explains what happens in public participation. And it also gives lots of great detail on what is a school board? What do we do? So if somebody's coming to that meeting for the first time, it's really creating that welcoming atmosphere and helping them understand how this meeting is going to run. Because if you think back to the first time you went to a public meeting, they're kind of awkward. They're not like many other meetings we go to. And there's definitely rules, and if you don't know them, it can be very intimidating. So as we talk through public participation, I'd encourage you, if you are going to public meetings, ask for and understand the rules around public comments before you comment. Ideally, the chair or the body will be giving these rules out, but just making sure that it's known can help for a smoother, more effective meeting for everybody. So these public participations, we had said earlier, the OMA requires, one public participation point in each public meeting. And these public meetings, this is an important distinction to understand. These are meetings of that public body that are held in public. Really, these meetings are about getting the business of that body done. These are not meetings of the public. If you've ever watched the show Gilmore Girls, and there are Stars Hollow town hall meetings that they go to where everybody sits in the big dance hall barn and gets to have their say and do some witty back and forth. That's not what many of these public body meetings are. They're there to do the business of the public body. And there's a very carved out and specific point for the public to participate. The point of this public participation is for that body to hear from the public and be informed, to get some more additional information. So it's that information sharing to the body, not a conversation. And here we have a quote from the OMA that a person must not be excluded from a meeting otherwise open to the public, except for a breach of peace actually committed at the meeting. So we'll often see this where a public body may have a frequent flyer who's known to disrupt meetings. Every time they come, it's a disruption, and it's been a continual problem. You cannot exclude that person unless they're committing a breach of peace actually at the meeting. So the OMA really has some strong protections for the public to attend these meetings. Now, the breach of peace needs to actually occur at that meeting, and it needs to be a true disruption. And in general, the courts have ruled that words alone are not a disruption. We even have a case where giving a Nazi salute in the back of the room isn't a disruption. Isn't that breach of the peace? It doesn't rise to that level. So it's pretty, again, that idea of the spirit of openness, the door shall remain open. However, when it comes to comment, public bodies can place limits on the time, place, or manner of public comment. Here we have another quote from the OMA. A person must be permitted to address a meeting of a public body under rules established and recorded by the public body. So the public body can't be just making up rules of, oh, wow, we're really busy tonight, so instead of 3 minutes, everybody's going to get 2. No, that probably isn't going to fly under the Open Meetings Act. They need to establish those rules in advance and have them recorded somewhere. So like on the Sault Ste. Marie Board of Education, they have their public comment rules printed out for visitors because they were established in advance. They know what they are. Many townships that I've been to will include it at the bottom of the agenda. Just a little note about rules for public comment so that everybody who has an agenda has that. Common one that we see is limiting the time each person can speak. public comment shall be limited to 3 minutes. And that is, again, to make it so that the public body can actually get to their business. We encourage in our trainings at Extension to have public bodies be cautious when limiting public comment, because this bumps right into the First Amendment of the US Constitution. And that First Amendment is very, very strong. So if we're thinking about limiting somebody's First Amendment rights, we need to have caution with that. So as a member of the public, just understanding those rules in advance can do a lot for making sure this public comment period goes a lot smoother. That being said, here are some of the tips we provide to public bodies about those public comment portions. Again, making sure you have your rules, having somebody, ideally staff, keep time. If a staff is keeping time, then the members can really focus in on the content of what's being said. Also, it helps to have a clock visible for the commenter too. I've been in that space where I'm like, all right, I've got 3 minutes to talk, and I all of a sudden have way too much stuff and only 10 more seconds, they said, shoot. So if it's nice if they have a clock that counts down for you. Another thing we advise these public body members of is this is not a dialogue. And that's one of the things I see a lot out and around the state is residents, members of the public will think that the public comment is their chance to ask questions, get answers. That's not what it's there for. It's there for the public body to receive information. It shouldn't be a dialogue back and forth. Shouldn't be asking and expecting questions. Oftentimes what we'll see is there'll be a follow-up after the meeting if there was a question. The superintendent of the school board will follow up with that individual and answer their question after the meeting. Again, it's not a conversation, and those comments need to be directed to the board. Public comment isn't the chance to grandstand. If you ever find yourself giving a public comment to a board and you turn to face the audience, you're getting off the rails a little bit. The audience, the rest of the public, they're not who you're speaking to. You're speaking to the board or the chair. And we encourage those members, the board, the chairs, to be an active listener, engaged, ideally thanking every speaker, even if it's negative. Again, there's that power imbalance. Coming up and saying something in front of a public body can be intimidating, even for somebody like me who does what I do for a living. So that thank you from a chair can really mean a lot. And then moving along, keeping things moving quickly so we can have an efficient and effective meeting. Now, a difference is a public hearing. This is a different type of meeting. It's different than a public comment. Public hearings are those meetings of the public. They often have a very spelled out procedure that must be followed, whether by law or regulation, local ordinance. And I see a lot of these in my planning and zoning work when there's a rezoning request, a variance request. These meetings will have a public hearing where there's a slightly different format being followed. So just know to recognize the difference between public comments and that public hearing. The minutes are going to be different for each. Public hearings the minutes will include the testimony from the public as part of the findings of fact, that record that they're creating. But there's not a requirement to include comments made during public comment in meeting minutes. I've seen some municipalities that do it, many don't. Again, that's where you get that local discretion about, okay, here are the standards from the OMA. What are we going to do as a public body, higher than that or not? So in summary, people have the right to attend a meeting of any public body unless one of those very specific exceptions apply. The public must be notified of that meeting in advance along those timelines that we went through. Minutes must be taken and then made available. And violations can result in actions being voided and civil or criminal sanctions being placed. So that sort of summarizes a lot of what we've been talking about. This is a quick sort of overview of the OMA. So I encourage everybody when the resources get sent out I'll be sending along this handbook from the Attorney General. It is a great resource to go through, and it takes this 9-page legalese state statute and breaks it down into some more digestible language and format. So if you want to start, I would start with the Attorney General's handbook as a next place. If you really want to dive into more, that handbook and my slides reference court cases. You can always look those up. And our MSU Extension government website has a lot of resources around the Open Meetings Act, meeting minutes, all of those great things as well. The one thing I'll note, and what often gets confusing for people, is keeping parliamentary procedure separate from Open Meetings Act and making sure we understand the differences between the two and when they apply. Parliamentary procedure is really your process for doing business. Often Robert's Rules of Order is the commonly used one. So that'll govern how a lot of decisions get made during a meeting. But know that not all public bodies use Robert's Rules of Order. Our own state legislature, I think, uses a different one, but understanding parliamentary procedure is a good next step for when you're actually at that public meeting to follow what's going on. So if you're not too familiar with parliamentary procedure, we have a whole web page with tons of resources about them. But yeah, again, MSU Extension is here to provide resources to everybody throughout the state. So that is my content, sort of going over the overview of Open Meetings Act, getting through the basics, those definitions, what happens before, during, and after. I'd like to check in now with Ruth to see if we got any questions coming in as I was going on and on there. And if not, that's okay, because I've got some other activities too.
Yes.
Yeah, we do have well, we don't have any questions in the chat yet. Maybe we'll give folks a chance to absorb and come to it. I have a question myself, though, and that is about how the Freedom of Information Act interacts with the Open Meetings Act. And so you mentioned somewhere earlier that, for instance, cell phones can be subject to FOIA, and I wondered if those closed session meeting minutes could be also, or you know, like what that does and how that is that used mostly to sort of implement, like if we think that if someone in the public thinks that it's the Open Meetings Act is not being followed, some like things like that. I wonder if you could speak a little bit to that.
So yeah, definitely. Thanks, Ruth. And I'll full disclosure, FOIA, the Freedom of Information Act, is not one of the state statutes that I generally give trainings on. So this is going to be a very surface level answer, and I apologize in advance for that. But please, my slides have contact information. If anybody has more specific questions, always feel free to email me, and I can reach out to my brain trust around the state and try and get some answers. But the first thing I would say is, if you're interested in the FOIA, our lovely Office of the Attorney General also has a FOIA handbook. That's a great resource to start to understand that. Specifically to the Open Meetings Act, I can't speak as to how people are using FOIA or what it might have to do for sort of that watchdog purpose. Just the reference that came up earlier was about those closed meetings and how those closed meeting minutes are likely not FOIA-able because they are expressly carved out by the state legislature to say, nope, these are things that can be discussed in private. If there's pending litigation, then maybe they come forth, but generally so. As to how FOIA gets used, sorry, I'm not too well versed on that, but point to the Office of Attorney General is a good starting point. If you have more questions, let us know here at Extension.
Okay, yeah, that's helpful. So it sounds like if someone felt like one of those closed sessions were, in fact, a decision had gotten made there and they were just coming back and sort of announcing their decision, a court case would have to be put out. Am I understanding your response there? Like you'd have to like sue or something.
There could be that challenge that we had talked about. What I will say is it's an important, there's a fine line there, right? Because they're going to be deliberating in that closed session. So there will often be a very robust conversation around, okay, well, what are we thinking? What would we like to do? What might a motion look like? how does this, what, and discussing all of those possibilities, because that's the point of the closed session, is to have those discussions in that closed off session. And then when they come back into the public meeting, oftentimes, yeah, the first thing is somebody makes the motion that does the decision that they had deliberated on in closed session. But that actual decision and the vote needs to be happening out in the public. Yeah, so, and I know as a member of the public, it can seem really weird. You know, you get ushered out of the room for half an hour, hour and a half, and you come back and all of a sudden, okay, everybody's on the same page, it seems, and here we go. But that's because they were doing those robust deliberations during the closed session.
It looks like Cheryl has a question. Jennifer, I don't know if you want to allow her to unmute or not, or otherwise you can write your question in the chat.
Yeah, so certainly, since we don't have a backlog of questions here, I'd be happy to unmute someone. If you raise your hand in the interactions there, Cheryl.
I can also do it if you prefer.
Yes, you could.
Hi, thank you. I wanted to let you know that the chat is not open for comments. So that's why you don't have any.
That's why
comments.
we don't have any. It's supposed to be, they've changed something again.
But my question is, if there is a public body that is holding meetings not in compliance with the Open Meetings Act, I'm not posting in advance, for example, 18 hours in advance, what is the process for filing in regards to a notice that they are in violation?
The Open Meetings Act talks about that process being challenged through the circuit court. I am not a lawyer. I cannot give legal advice from MSU Extension. So if you are in that situation and you would like that legal counsel, I would advise you, the Michigan Bar Association actually has a really great lawyer search tool where you can find practicing attorneys who have experience with municipal law who may be able to give that actual legal advice. What I will say is, in addition to those sort of going to the circuit court options that are outlined in the statute, conversations can often do a lot of great work in this space where, yes, we could go through the courts, but also maybe it's just a conversation with that public body, reaching out to the chair, the staff, and raising your concerns, understanding and bringing forth, hey, this is what I'm noticing. I'm a little worried that it may be a violation of the Open Meetings Act. Can we discuss it? And that's one of the reasons why I get drawn to local government, is because it's government with your neighbors. You can have those conversations. These are the folks you're likely going to see at the supermarket. So start there. If you think there are some potential violations, start with that conversation first. You can often get a lot done with just that, and really, help educate. We have a lot of statutes and laws that these public officials are dealing with. So making sure that everybody knows what the requirements are can often be the first step towards that compliance. Because really, a lot of people want to comply with this stuff. It's just understanding how. So sorry, that was another kind of non-answer for you there, Cheryl, but some places to start at least. And if you do need that link to the Michigan Bar Association, shoot me an email and I am more than happy to provide it.
I am
have
going
a
to
couple-
say that I have enabled the chat for everybody, and you can ask to be unmuted by raising your hand.
Thank you, Jennifer. We do have a couple more questions coming in now. Thank you. So we have from, are there any requirements for committee meetings apart from regular meetings? So I guess in that particular kind of group, are there any special requirements for committees?
Yeah, so with committees, and the Attorney General's OMA handbook has a great section on this as well, I believe. But committees are a public body. If they are deliberating or making a decision or effectuating public policy, then the OMA is going to apply to that committee as a public body. Now, there are some nuances to it here where sometimes there are committees that meet and it's more informational. They don't actually reduce the number of options. They're not making any decisions in that committee. Everything ends up being discussed as the full body. Those may be exempt from the strict application of the Open Meetings Act. What we also like to say, though, is remember, this is setting that minimum. So are there ways that public bodies may want to go above the minimum standards set by the OMA of maybe just having all committee meetings be posted and publicly available? We see that in some spaces. So you do get that variation around the state, but the requirements for committee meetings would be the same as any other public body. If they're deliberating, making that decision, then the OMA is going to apply to that committee as well.
Great, thank you. And then just to clarify, the public body does not have to post an agenda, correct?
Under the Open Meetings Act, that is correct. There is no requirement to post that agenda or the topic of the meeting. Now, again, we're setting that minimum. Lots of communities will go above that. I get a lovely email from my county every time they post the new agenda for the upcoming meetings. So you get that variation, but there's not a requirement. But again, thinking about the spirit of it, openness, transparency, allowing the public to participate, it could be something to bring up to your elected or appointed officials of, hey, it's really hard for me to, know what's going on. And if I need to hustle here after work to watch the public meeting, could we get the agendas in advance? Again, that idea that, conversation, asking the questions with those that are actually involved can really lead to some positive changes here and maybe cause folks to think, is how we're doing things the way that we are going to continue to do them.
Thank you. Then how does the OMA apply to open meetings held electronically over software like Zoom?
So this gets back to that conversation we were having earlier about all of the pandemic amendments that had happened to the Open Meetings Act. So as of January 1st, 2022, all the members of a public body must be physically present unless they're on active military duty. So it means basically I don't see many folks dialing in via phone or Zoom as a member of a public body. That's kind of gone by the wayside as of 2022. For public participation, the OMA, again, if a public body is streaming out, it's probably best to make sure that that is available for everybody to get into, to make sure that it's accessible. The difference would be when it comes to public comment. Those rules defined in advance may mean that you have to be in person to give a public comment. Some may allow public comments from the virtual audience. I've been to meetings that do both. Again, it's that local choice that's empowered by those public comment rules defined in advance. So if you're seeing those open meetings that are held electronically over Zoom, they're probably broadcasting out what is happening in a physical location for those public bodies subject to those aspects of the OMA. Again, there are a couple wonky like state level boards, like maybe some of the commodities groups I think get carve outs for this, but I haven't dug into those sections too much because they are so niche.
I have another question of my own as we wait for maybe other folks to write their own. How are there any provisions for accessibility in the way of like disabilities, for instance? Are there any provisions in the act itself, or do we require? Is it more about like in another act that is providing for that?
You hit it right on the head there at the end, Ruth. Those accessibility things are going to come from a different state statute. We're looking to our American with Disabilities Act or the Michigan Rehabilitation Act, I believe it is. In the slides, I reference an Attorney General opinion from February of 2022 that talks specifically about that in relationship to those virtual meetings and allowing virtual viewing of the meeting as a means of accommodation under the ADA. So if you're interested in that intersection between open meetings and accessibility, that OAG opinion would be a great place to start. Because, oh my God, if you guys haven't read Office of the Attorney General opinions, they're really fun because it's essentially somebody asks a question to the Attorney General about a law, and they come back with what their interpretation is, and often a lot of history too, and court cases and all sorts of stuff. So if you're looking for that deep dive, those can really be a good launch pad to get the basics, a nice succinct answer to what the question was, and then also additional places to continue your research.
And I have only one more. I really appreciate your willingness to answer my questions. This is coming more from my own background as an artist or designer, and I appreciate that you work also with developments. What is the scale of decision that gets made, maybe? So for instance, if I were given a grant or like a commission from a public body to make a work, is that then the decision and that's final, or is it required then that I give more meetings as I make decisions on what my art might be or what the design of a thing might be? And if then it gets changed as things get fabricated, does that have to be, is that an emergency like notice that we just decide that it's okay? What are the scales of those things that happen?
Yeah, and for that question, really going to focus in on when does the Open Meetings Act apply? And so as we go through the act and you read it, applies to those public bodies making decisions, doing their governmental work, essentially. And so in that instance where there was like a grant from a township to an artist to paint the mural, so we have great placemaking and more people want to come, that artist isn't a public body. Those decisions that an artist would be making wouldn't be subject to the Open Meetings Act. Now, the decisions that the public body makes about how do we award this grant, who are we going to select, from the public body's perspective, yes, those are very much decisions that need to be noticed and discussed in public. But it doesn't, the OMA doesn't sort of trickle out into vendors or contractors or grantees or those sorts of things. Now, if there are those public decisions to be made, then yeah, they would be happening at a public body, and it may behoove the person to be there to answer questions, do that sort of thing. But again, is that public body making a public decision there?
Yeah, we have another question in the chat. Is there any special requirements for notices for meetings that include the budget hearing? Does the notice need to be printed in a newspaper?
So this is to that ADA question we had, where in the OMA, no, but we have a lot of state statutes. And again, this is one that I haven't dealt with recently, but I'm thinking in one of our other state statutes, there are some pretty laid out requirements around the budgetary process. And if you have questions about those, I do some programs with the Michigan Department of Treasury. They are phenomenal and have a great website with lots of resources too about that budget process and those questions. So if you'd like specifics on that and what statute might apply, Linda, please shoot me an email. I can do some digging on it. But under the OMA, no, but know that the OMA is just one law in our state. So it's important to check those other ones that may grant authority or outline how that process works.
Cheryl, I think you can unmute.
Oh, thank you. Sorry, I did send this out, but are there two questions I have? One is, 18 hours is not very much for a person to get notice by mail. I mean, we are lucky if we do get it in a couple of days, but how much emphasis has been put on it, on including people who don't use or can't use the internet, or who can't easily come there to get the information and be there, or to even get the notices? So have people raised that issue very much with these bodies or with the Michigan whoever details all of this?
So I'm sure our state elected officials get tons of concerns from across the state. I'm not privy to all of those, but for my own local government meetings I've gone to, yeah, it is a thing that gets brought up. I was just at a township meeting last night where somebody mentioned how, you know, they were talking about needing a special meeting, and somebody said, well, can we know when it's going to be now? Because I can't drive here and check your bulletin board outside every day, because it was one of those townships that doesn't have a web presence at all. Everything is very much so. It's posted right there out in front, and that's our notice. It is a concern. Again, go back to my mantra for the evening of the OMA is really setting the minimum. These public bodies can consider, and if their constituents, the public, is wanting more transparency, more access, that's a concern that you can raise and have that conversation, or make it known that, hey, you know, here's a situation that our residents are experiencing. Are there other ways we can make sure that they can get involved in government? Now, the OMA isn't going to speak to that specifically, and great point about that 18-hour notice and our mail system. It, yeah, doesn't tend to work that quick. But again, those are sort of those special meetings, unique. Most of the meetings are hopefully being posted in that regular session. But no, it is a concern. And yeah, if you're feeling as a resident that you're not able to stay up to date, then yeah, definitely raise that with a public body and offer some suggestions of ways that, you know, maybe have you considered this? There was a local unit of government I saw that started just snapping a picture of the agenda and putting it on their Facebook page. Not a requirement of the OMA, but they had a lot of people engaging with their Facebook page and wondering what was going to be happening at the meeting. So they started doing that. That was what people were asking for. And that was one of their ways to sort of say, hey, you can stay up to date. We're going to let you know. Here's what we're talking about. So there are some options for how to consider that. And yeah, always, please feel empowered to bring up these concerns to your public bodies.
Thank you.
Public
Thank you.
comment
I
could be
see
a
now
great
your
place to do it.
Can I ask one more question? Also, what do other states' MOAs look like? I mean, are we doing well here in the state, or are we behind on certain kinds of rules and requirements?
So one of the benefits of my position here at Michigan State University Extension is I get the pleasure of just focusing on Michigan and our laws. I
Okay.
do not know and can't speak to what other states are doing. I imagine there are some organizations that take stock of that, but I am blanking on them offhand right now, but not something I can speak to as sort of generality.
That's fine.
I can
Thank you.
say though, and when we got our OMA, a lot of other states in that Watergate era were doing similar sunshine type laws to increase transparency. So it was a wave we saw back then that we caught with quite a few other states, but can't speak to comparisons right now. Apologies.
No.
And that is all the questions I see in the chat. If there's anyone else. No.
I don't see anything else. I do want to say that if anyone who attends these regularly notices in the future that you can't use the chat, send me an email. Excuse me. Double copying this. So please send me an email. I do monitor the email during the program. At least one person wasn't able to connect.
Real
But
quick,
thank you.
Jennifer, as
What?
we're wrapping up,
Mhm.
I'd like to share my screen once more and highlight a resource that a lot of folks don't know about from Extension
Yes.
that is a good sort of follow-up here.
Mhm.
If you do find you have more questions about Open Meetings Act or really anything else, what is this bug? How do I get my garden bed ready for the spring? How do I know if my canned tomatoes are still good to eat? Any of those questions, if you go to our MSU Extension homepage, just search MSU Extension, you'll get a lovely page like this with lots of soybeans in the background. And right here, this Ask Extension. This is our tool for folks from all around the state. If you click on it, it is just a handy little form where you can type up your question, add pictures if you need, and that gets sent to our educators and staff all around the state, depending on their expertise. So if you ask a planning and zoning question, it's going to come to my team. Ask a gardening question, it's going to go to our awesome master gardeners and our horticulture team. But just know, if you're ever unsure about something, MSU Extension and our Ask Extension tool is a great resource to kind of take that first step towards getting an answer. We might not always have the answer, but we can point you in a direction and hopefully get you in contact with somebody who does.
Well, thank you, Tyler. It was a very informative program. We've had several very positive comments.
Yeah.
And this recording will be available on our special channel for the League on the Detroit Public Library's YouTube channel. And it will also be available on the League's website, the Detroit League's website. Thank you very much. I thank you for everyone that attended. I'm hopefully going to learn how to do this again, given that I've had some problems. Well, they also change the interface every month, frequently, not every month. Thank you.
Thanks.
Yeah, thank you.
And I will send that email. I drafted that email, Tyler. So I will send it.
Awesome. Thank you very much.